All right, welcome everyone. We're here on the record, and this is the matters of people of the state of Michigan versus Matthew John Lehman. These are four different files: 25-3400FH, 25-3401FH, 25-3402FH, and 25-3404FH. Council, if you could place your appearances to begin, please.
Jeremiah Buffalo Wargo, P77997 on behalf of the people.
William Pfeiffer, P45236 on behalf of Matthew Lehman.
Thank you. And sir, are you Matthew Lehman? Sir, are you Matthew Lehman?
Am I Matthew Lehman? Yes, I am.
All right. Mr. Lehman, we're here today. Council, I'll start by addressing you. I'm Judge Hunter. I'm from the 46th Circuit Court, which is Crawford, Otsego, and Kalkaska. I've been assigned by the State Court Administrator's Office. I know this is an Alpena County 26th Circuit Court case. I want to first make sure I'm here for the right purpose in terms of my understanding. It looked like this was an arraignment on an information. Is that accurate, Mr. Pfeiffer?
It is, Your Honor.
Have you had a chance to go over all of those informations, the various four different cases with Mr. Lehman?
Your Honor, I was not able to go over it today, but I have went over it with him in the past, yes.
Mr. Lehman, you appeared demonstrative to me, and you were just making this motion with your hands. I don't know what that means, so why don't you try to explain it for me?
Oh, you were just asking him if he just went over everything with me. We didn't have enough time to go over everything. There's a lot more I want to go over with him.
Well, I'm sure there's many more things that you want to go over, but the purpose of this hearing is relatively limited. That's why I asked your attorney. But now I'll ask you. The purpose of an arraignment on an information is to determine whether or not you've reviewed the charges against you, whether or not you understand them, and whether or not you understand the maximum penalties. That is not a question of whether or not you agree with the charges, or if you need more time to talk with your attorney about them. That's why the limited question to your attorney was what it was. So the question for you, Mr. Lehman, is, do you want me to read the charges on the open court record, or do you know what the charges are?
I have some idea what the charges are and what some of the maximum sentences are.
Well, some is not appropriate to this court, and so what I'll do is take the time that's necessary to go through each and every one of the charges, Mr. Lehman, because it's important that you understand them. More specifically, it's more important to me that you're aware of them. I can't possibly force you to understand them or agree with them, but I will make sure that you have every opportunity to understand the nature of the charges. In the first file that's been filed against you, Mr. Lehman, your charges are the following. The prosecutor has alleged by the information that he's filed that on or about 7/21 or July 21st of 2025, with regard to count one, that you did threaten to commit an act of terrorism and did communicate that threat to another person contrary to statute. That offense, if you're convicted of it, is a felony offense, and the maximum punishment for that felony is up to 20 years in the state prison system and/or a fine of up to $20,000. You must reimburse the government for expenses incurred from the violation if the court so orders if you're convicted of that offense. Do you understand the name of that offense and the maximum penalty?
Yes, I do, Your Honor.
Count two in the information there charges you with the offense known as false report of a threat or terrorism, and that alleges that you did threaten to commit an act of terrorism and did communicate that threat to another person contrary to statute. Again, count two is a felony offense. The maximum punishment for that felony is up to 20 years in the state prison system and or a fine of up to $20,000. The court has the opportunity to order you to reimburse the government for expenses incurred from a violation of that statute. Finally, in count three, you're charged with the offense of interfering with the crime report. The prosecutor alleges that you did retaliate or attempt to retaliate against another person for having reported or attempted to report a crime committed or attempted by another person contrary to statute. That particular offense is a misdemeanor offense, and the maximum punishment is 1 year in the county jail and or a $1,000 fine. The consecutive sentence may be imposed for any other conviction. Are you now aware of the charges that have been filed against you and their maximum penalties in that file?
Yes, I am, Your Honor.
Turning to file number 25-3401FH. In that particular case, the information charges you with the offense of count one, malicious destruction of fire or police property. In that case, the prosecutor charges that on or about July 21st of 2025, that you did willfully and maliciously destroy or injure certain personal property, to wit, a security or surveillance camera belonging to or possessed by the Alpena County Jail contrary to statute. That offense is also a felony offense, and the maximum punishment for that felony offense is 4 years in the state prison system and or a fine of up to $5,000. Did you have a question, sir?
Oh, no, I was just pointing out, I'm in the exact cell where I did it. It was that camera up there that I broke with
Mr. Lehman,
the
let
broom.
me make this more simple for you. This is not a hearing where I'm making factual determinations. This is not a hearing where I've yet sought input from you except as to limited questions. And those limited questions are these following. Have you had a chance to read the allegations against you? Do you understand the charges? And do you understand the maximum penalty?
Yes,
That's it. That's all I'm asking, and that's all I'm permitting. So any of the commentary that you might have, you can save it for your attorney and or for a jury and or for me if you determine to have a bench trial. But the focus of this hearing is not for you to tell me anything else about the case. Do you understand?
Yes, I do, Your Honor.
So do you understand the nature of the charge and the maximum penalty associated with count 1 in the second file?
Yes, I do, Your Honor.
Count 2 charges you with the offense of malicious destruction. Mr. Lehman, I intend to keep talking, and I'm going to keep talking because you are already tending to make this job more difficult than it needs to be. I say that because this is a simple procedure. And when you're laughing, it suggests to me more that what I'm suspecting is the truth, that you're intentionally trying to impede the role that I have, the role that Mr. Wergau has, the role that the Alpena County Circuit Court has, or the role that even your own attorney has. If my suspicion in that regard is continued and I make a finding, I'm simply going to remove you from this court proceeding and I'll conduct it with your attorney. However, that's an extreme measure. I don't want to take that action. But I am not going to allow you to turn this hearing into a mockery. And if you continue to act like this is a funny proceeding, I will view you as having waived your right to participate. Do you understand what I've said?
Yes, I do, Your Honor.
Do I need to repeat any of that circumstance more specifically for you?
No, you do not, Your Honor.
Then you should act accordingly. You should listen carefully to the things I'm saying, and you should answer only those inquiries that I put to you. Count 2 in the second file, 25-3401FH, charges you with the offense of malicious destruction of fire or police property. If convicted, that also is a felony offense. Maximum potential punishment, up to 4 years in the state prison system and or a fine of up to $5,000. Do you understand the name of that offense and the maximum penalty?
Yes, I do.
Count 3 charges you with malicious destruction of fire or police property. It alleges that you did willfully or maliciously destroy or injure certain personal property, to wit, a broom belonging to or possessed by the Alpena County Jail, contrary to statute. Again, that offense is a felony offense. The maximum punishment is 4 years in the state prison system and $5,000 maximum fine. Do you understand the maximum penalty associated with that offense?
Yes, I do, Your Honor.
Each of those 3 counts are subject to what's called a habitual offender second offense notice. If you're convicted as a habitual offender second offense notice, the effect is that each of those felony offenses is punishable by 1.5 times the amounts that I just said. So for example, count 1, count 2, and count 3, rather than having a 4-year maximum, would have a 6-year maximum under the statutes. Do you understand that maximum penalty?
Yes, I do, Your Honor.
With regard to file 25-3402FH, Mr. Lehman, you are charged with several different offenses therein. With regard to that case, the prosecutor alleges that on or about July 21st of 2025, in count 1, that you committed the offense of home invasion first degree. The allegation reads and claims that you did break and enter or did enter without permission a dwelling located at 1 North, and while entering, present in, or exiting, did commit an assault. And while entering, present in, or exiting the dwelling, Brandy Allen Bridges was lawfully present therein, contrary to statute. That offense, if you're convicted, is a felony offense, and the maximum punishment for that felony is up to 20 years in the state prison system and or a fine of up to $5,000. That offense is also punishable by consecutive sentencing if you're convicted of any other conviction arising from the same transaction or occurrence. Do you understand the nature of that charge and its maximum penalty?
Yes, I do, Your Honor.
In count 2, you're charged with the offense known as criminal sexual conduct in the 4th degree, force or coercion. The prosecutor reads and alleges that you did engage in sexual contact with another person, to wit, Brandy Allen Bridges, using force or coercion to accomplish the sexual contact contrary to statute. Do you understand that allegation so far?
Yes, I do, Your Honor.
That is a Tier 1 offense under the Sex Offenders Registration Act if the victim was 18 years of age or older. It's a Tier 2 offense if the defendant has a prior conviction for a Tier 1 offense. It's a Tier 2 offense if the victim was between the ages of 13 to 17 inclusive. And it's a Tier 3 offense if the victim was under 13 years and the defendant was 17 years of age or older. It's a Tier 3 offense if the defendant has a prior conviction for a Tier 2 offense. Take notice that pursuant to the statute, upon bind over, to the circuit court, the district court judge shall order the defendant to be tested for venereal disease, hepatitis B infection, and for the presence of HIV or an antibody to HIV. If that judge determined that there's a reason to believe that the violation involved sexual penetration or exposure to a bodily fluid of the defendant. If the district judge made that determination that testing is not required, then upon conviction, the court must order you to be tested. Do you understand those provisions?
Yes, I do, Your Honor.
The maximum penalty for that offense, it's called a high court misdemeanor. In Michigan, that's also known as a felony. That's because it's punishable by more than 1 year in the county jail. The maximum penalty for that offense is 2 years in the state prison system and or a fine of up to $500. Are you aware of that maximum penalty?
Yes, I am, Your Honor.
Count 3 charges you with the offense of police officer, assault, resist, or obstruct. It alleges that you did assault, batter, wound, resist, obstruct, oppose, or endanger Terry Curtis, who was a police officer with the Alpena Police Department, that the defendant knew or had reason to know was performing his or her duties contrary to statute. That offense is a felony offense with a maximum punishment of 2 years in the state prison system and or a fine of up to $2,000. A consecutive sentence can be imposed under one statute if the assault was committed in a place of confinement or under a separate statute for another violation arising from the same transaction or occurrence. Do you understand the nature of that charge as well as its maximum penalty?
Yes, I do, Your Honor.
Again, for these charges, the prosecutor suggests that you are a habitual offender second offense notice. If that's found by the court to be true, that means that each of the penalties that I've just outlined is increased by 1 1/2 times. That means count 1, home invasion first degree, could carry with it a maximum of 30 years in the state prison system. Criminal sexual conduct fourth degree in count 2 could carry with it a maximum of 3 years in the state prison system. And count 3, police officer, assault, resist, or obstruct, could carry with it a maximum of 3 years in the state prison system. Are you aware of those maximum penalties under the habitual claim?
Yes, I am, Your Honor.
Finally, in claim 25 case number 25-3404FH, the prosecutor alleges that on or about July 11, 2025, with respect to count 1, that you did make an assault upon Thomas Michael Patel Jr. by strangulation or suffocation, contrary to statute. That is a felony offense with a maximum potential punishment of up to 10 years in the state prison system and or a fine of up to $5,000. DNA must be taken upon your arrest. If it was not taken upon your arrest, it would be ordered to be taken upon your conviction. A consecutive sentence may be imposed under the statute if the assault was committed in a place of confinement. Do you understand the maximum penalties associated with that charge?
I do, Your Honor.
You're also charged as a habitual offender second offense notice, meaning that if you were convicted, that penalty would rise by 1 1/2 times, meaning the maximum penalty is 15 years in the state prison system for count 1. Do you understand that?
Do.
Count 2 charges you with the offense known as assault with intent to maim. That alleges that you did make an assault upon Thomas Jr. with the intent to maim or disfigure said person by cutting or tearing off an ear, contrary to statute. That is also a felony offense. That felony offense is punishable by a maximum of 10 years in the state prison system and or a fine of up to $5,000. DNA must be taken upon your arrest. If it was not taken upon your arrest, it would be ordered by the court to be taken in the event you were convicted, and a consecutive sentence may be imposed under the statute if the assault was committed in a place of confinement. Once again, you're charged as a habitual offender second offense notice, making the maximum penalty for assault with intent to maim up to 15 years in the state prison system. Do you understand the nature of that charge as well as its maximum penalty?
Yes, I do, Your Honor.
You have the right to remain silent throughout these proceedings. If you don't remain silent, anything that you say on the open court record or in any writing could be used against you. You have the right to be represented by counsel. Here's Mr. Pfeiffer is going to do that adequately for you. Mr. Pfeiffer, with that reading, do you have anything formally that you would like to cover further in terms of the arraignment on the information?
There's just one issue. I'm not sure if Mr. Wergo is aware of this, but count 2 of the last file, the assault with intent to maim, was dismissed at the district court level. So
I was not aware of that. I appreciate that clarification. Is that correct, Mr. Wergo?
I do believe it is, Your Honor.
All right. And so all of the other charges, though, still remain. Is that right, Mr. Pfeiffer?
Absolutely, Your Honor.
All right. So that is a fair and important clarification. Count 2 in that last file, assault with intent to maim, has been dismissed. Are you now aware of that? Mr. Lehman?
Oh, yes. Yes, I am, Your Honor.
And that's where the reality of the courtroom truly hits. The law isn't about emotions, it's about understanding responsibility, facing the charges, and letting justice take its course. Whether you win or lose in court, the system moves forward based on facts, evidence, and procedure, not defiance or distractions. In the end, every courtroom story reminds us that actions have consequences, and justice always seeks the truth.